Thank you so much for that, Faye. That was such useful insight and resource for our members and our associations to learn about what resources are out there for them, but also I think to keep their antenna up about our obligations to the public, to our counterparts, to our colleagues in this professional space. So thank you to Diana and Faye for your time this morning. We appreciate your continued interest at the Law Society and engaging with FOLA on the work underway from a governance perspective, from a resource perspective, and we'll look forward to that continued partnership and discussion as these important programs unfold. We're a little behind schedule, so I'm going to quickly and ungraciously stumble into our next piece, and staying today with I think the theme of change and technology that we've all become accustomed to. Our next speaker is Will Morrison. Will is the, pardon me, is the Access to Innovation Manager at the Law Society. We've heard some overview of his area in Diana's presentation. And he's here to update us on the Law Society SANDBOX technology initiative. Will comes to the Law Society from tours of duty at the Ministry of the Attorney General and Blake's. Will, I'm going to turn the floor to you, and I apologize, we've eaten into 10 minutes of your time, so I'm hoping that you can help us recover some of that as we move ahead today.
I will try to do that. Thanks very much to everyone for having me. I've got a PowerPoint, so let me just share that. Hope everyone can see that. And so thank you, everyone. Really appreciate the opportunity to be here, and I will try to make up a little bit of time where I can. Late last year, sorry, I'm having a bit of trouble, computer trouble. Sorry about that. Late last year, the Law Society launched the Access to Innovation project. We also call it A2I, or we call it the SANDBOX. And with the time I have, I just want to take you through what Access to Innovation is all about, where it came from, why we think it's such an important opportunity, who's involved, and how you can keep up with what we're doing. So I want to leave time for Q&A if we have it. And as I said, I've provided a copy of the slides, so I'll skim over a few of them in the interest of time. So I just want to start by offering a high-level overview of the project. And the purpose is to take a new approach to regulating what we call direct-to-public legal technologies, an approach that's more conducive to innovation, that is more assuring to people who need legal help, and is more effective and sustainable in an increasingly digital environment. So when we say direct-to-public legal technologies, or sometimes we say innovative technological legal services, what we're really talking about are tools people can use to get legal help through websites, apps, software, or some other technological interface. And I'll give you a couple of examples drawing on services you may already be familiar with. So you can think of tax preparation software that might be fresh in mind for some of you, online platforms that guide you through preparing your income tax returns. A similar kind of service can exist in law. For example, a platform that would guide you through the preparation of your will or your power of attorney documents, or that would help you prepare a legal document in a dispute with your landlord. We'd call that direct-to-public legal technology. You could also think of investment management services available through your bank's app on your smartphone. A similar kind of service could be delivered by a practicing lawyer or law firm to their clients, for example, to small businesses to automate the management of routine and ongoing legal documents and legal processes that they have. We would also call that direct-to-public legal technology. The key idea here is really that the legal services are being delivered to an end user, who's the client, through innovative technology. And what we're doing with our SANDBOX is inviting providers of these kinds of services to operate within a regulatory safe zone while complying with public protection requirements that we supervise. So applicants who are approved to participate agree to a supervised operating period, and they report data about their processes and outcomes during that period. And those providers who meet expectations during their operating period can then obtain a permit from the Law Society, which would enable them to continue providing legal services in Ontario. So this is first and foremost an access to justice initiative. It's trying to focus on the modern needs and interests of Ontarians who are looking for legal help. And we see legal technological innovation as one among many avenues to better meet those needs. But it's also a project that's designed to enhance public protection in this field, to facilitate better legal innovation, to support our regulatory policy making, and to help legal professionals and the public learn about developments in technology and innovation. So why are we doing this? I just want to start by putting you in our shoes, setting out the issues for you and the landscape as we see it as the regulator. So we've been grappling with several concurrent trends. They're the ones listed on this slide. And I'd like to take a moment now and just drill down on each of them. The first is access to justice, as I said, is the primary driver of this project. The research is consistent and it's clear. It tells us that over any 3-year period, nearly half of all Canadian adults will experience at least one legal problem that they consider serious and difficult to resolve. It also tells us that despite those everyday needs, Canadians don't seek professional assistance from a lawyer or paralegal more than 80% of the time. And we know that tech is never a panacea for what are essentially societal and structural problems, but we also believe that tech can play an important role in improving access to quality legal help. And the second trend is over the past decade or so, we've begun to see a dramatic rise in the capabilities of new legal tech tools. So there have been major advances in areas like process automation, data analytics, natural language processing, and artificial intelligence and machine learning. At the same time, third trend, we can also see market forces encouraging people who provide legal services to adopt technologies. There are pressures on prices for legal services. Clients are seeking more transparency and more from legal professionals. Increasingly, we as consumers want to be able to access services on demand, around the clock, whenever best fits our schedule. So if you combine those three trends, you've got help with everyday problems becoming increasingly out of reach, technologies becoming more capable of assisting, and consumers becoming more interested in receiving professional services through technology. We get that steep rise in recent years in the development of these tech-enabled legal services. And these are innovations that we would say offer promising opportunities for the public and for access to justice. They're also services, despite that potential, that are still developing. And by their nature, they pose some unique and novel kinds of public protection concerns. And it's also unclear in many cases whether our current or existing regulatory framework allows people to provide these kinds of services in the way that they want to. So that poses challenges for us, it poses challenges for the innovators, and most of all for the people who want to use those services. And that takes us to the fourth trend. People from inside and outside the legal professions are trying to find new ways to reach that consumer demand, especially trying to reach that 80% of demand that you could say is untapped by lawyers and paralegals today. And in most cases, they're running very quickly into challenges with a regulatory framework that, while it has served and continues to serve many valuable purposes, was not designed for the level of tech involvement in service delivery that we see today. So when people come up with new ideas to provide help, oftentimes those are clearly barred by the Law Society Act or by the rules of professional conduct or our bylaws, or at least it's unclear whether they're permitted. And those barriers and that uncertainty can stifle innovation. It can also have perverse or unintended consequences in the sense that well-meaning people, actors who proactively try to comply with the regulatory framework run into hurdles. They can't find help getting over those hurdles, and they just give up their efforts. And meanwhile, if we have other service providers who decide to operate anyway, they end up positioned outside of the regulatory framework. That means that people who are interested in receiving those services can't get assurance that there's a regulator or there's standards standing behind them, or that there will be recourse available if something goes wrong. So that was the status quo. And for all the risks involved in doing things differently, that status quo showed us that there are also risks in failing to take action or failing to keep pace. And these trends were what led us to a regulatory sandbox, a pilot project that can foster effective development of innovative new kinds of services within a supervised environment that protects the public. So sandboxes, I'll just give you a quick slide on them. They are a popular policy tool these days. They give clear time-limited permission for vetted providers to deliver their services while complying with operating requirements. And by doing that, they can encourage the development and operation of new kinds of services. Financial services regulators first developed the concept for the same kinds of reasons that we have. And now in the legal world, as you can see on the slide, other similar sandboxes to ours have been started. Each of those sandboxes launched by law societies in Canada has slightly different emphasis, slightly different focus. Ours in Ontario is the most specifically technology focused, for example. But I don't want to overemphasize the differences because at the core and in terms of their objectives, they're all quite similar. And while I think Ontario and these other Canadian provinces can fairly be seen as a leader in this area, I expect that if we look ahead a few years, our sandbox will look like one among many. So let me just get into how it works. Anyone who wants to provide legal assistance to people in an innovative way and in a way that faces some regulatory barriers or uncertainty can apply to participate. And when we receive applications, our team, which includes our independent advisor, who I'll speak more about shortly, our team reviews the proposed service to ensure that it offers appropriate markers of quality and also that it mitigates risks of harm involved. And there are several key risks of harm that we look out for, both at the application stage and when we're monitoring approved participants in the sandbox. The main ones are the four listed on this slide. These are essentially the same kinds of concepts that underpin lawyer and paralegal regulation. It's of competent services and ethical and professional conduct. And because we're talking about services that are mostly marketed to people who've often had barriers accessing professional legal help, we want to be particularly careful that we are striking an appropriate balance between the need to expand access and the need to ensure that vulnerable users are protected from harms. So working with our advisory council, we've developed detailed approval criteria. We use those as kind of a scorecard when we're reviewing applications. And we've published that criteria on our website. We're trying to be very transparent in the work that we're doing with this sandbox. And as we review for risks and safeguards, we also think about operating requirements and standards that we'll put in place as conditions of approval for each applicant. So to extend the metaphor, you can think of these as akin to the bylaws or the rules of professional conduct, but designed specifically for the unique circumstances of each approved participant. So you see on this slide some of the operating conditions that we expect will be common to all or most participants. I won't go over each of them, I'll just rely on the slide here. And I gave a really brief summary at the outset of how the process works once providers are approved to participate in our sandbox. I'll let this busy looking slide fill out a little more detail for you, but I just wanted to touch on, after each participant has completed their time in the sandbox, we use the evidence that we've learned from the experience to assess whether they've met their objectives, whether they have the right tools in place. And for those who've succeeded, which we hope will be all participants, they can receive a new kind of permit to continue operating in Ontario. And the parameters of these permits are still to be developed through convocation, And we'll be using the evidence and experience that we gain through the sandbox to inform that development. And more broadly as well, what we learned through this initiative, we also aim to inform our own evaluation of existing rules and regulations to ensure that they're keeping up, that they're effective and sustainable in a sector that's evolving. So the sandbox is a 5-year pilot project. We just began accepting applications in November. Feedback and interest has been really positive so far. We've received numerous applications already. They're in the process of being reviewed, and we're close now to announcing our first approvals. And I expect applications will continue coming in from various different directions. There are legal technology companies at all stages of development who are looking to provide these kinds of legal services directly to end users. These are mostly businesses that have been started by legal professionals, people who've been exploring different ways of delivering services. And there's a lot of opportunity here for them. We also get a lot of interest from everyday practicing legal professionals, usually sole or small firm lawyers so far, people who've reached out, who've said, they've been innovating with tech in interesting ways within their practice for a while now. They learned about the sandbox, and now they've seen it as an opportunity to bring their innovative ideas out from the back office and directly to the clients they serve. So for that group, it could allow them to organize their delivery model differently, reach more clients, maybe reach new kinds of clients in different locations in Ontario. And so overall, by the end of the full 5 years of our project, we're hoping to see at least 5 key outcomes. We want to help expand people's access to a really healthy market of new and innovative kinds of services. We want to help people make informed choices about the innovative services they receive, to help them feel confident that these services are properly vetted, and to help them feel that they have similar kinds of protections to those that are available to clients of lawyers and paralegals. We also want to help ensure that people have access to effective complaint resolution processes when things go wrong. And by highlighting innovative ways to provide services, we're also hoping to help legal professionals understand the opportunities and the challenges associated with legal tech. And the last goal is to try to evolve our regulatory framework towards something that encourages ongoing innovation, but also ensures that the public receives effective and accessible assistance in an increasingly tech-enabled future. So we designed the sandbox with the idea of using independent expertise to help review applications, steer strategic directions, and give us perspectives from outside the Law Society's walls. Our advisory council on this slide is composed of 12 people from a wide array of professional backgrounds and perspectives. We have experts from the practicing legal professions, from the legal tech and innovation world, from legal ethics and regulation, the public sector, academia, and members of the public from other communities and industries beyond law. So you can see the names of the members on this slide. This advisory council, we've met many times since the fall. I can tell you it's a fantastic group, engaged and insightful, and just what we were looking for. On the next slide, I'll just show you as well that we set up a stakeholder roundtable looking for other ways of engaging the legal community in this project. So our roundtable is a group of representatives from numerous partner organizations in the legal community who meet to receive updates and share their perspectives on the project. We've been really pleased that FOLA has been participating in the roundtable, and you can see the other names of the other organizations represented here. And we're also going out and trying to engage the community in as many ways as we can through presentations like this, which I really appreciate. We're always encouraging people to stay engaged with this, to give us feedback, to keep up with it. We'll be communicating regular updates about this sandbox through a variety of channels, from social media posts, newsletters, convocation reports. So please do stay tuned for all of that. I really do hope you'll join us. And If your particular organization is interested, I'm happy to come and speak at any time. Happy to speak to you directly if you have any questions or suggestions. Please don't hesitate to reach out. So with that, I thank you very much for your attention. I know I've sort of raced through it, but I hope that this has been a helpful orientation to our SANDBOX project. Thank you very much.
Thank you, Will. That was really informative and really interesting. And I appreciate all the work and engagement that appears to be going into this initiative on your part and the part of those involved in the in those last couple slides you were sharing with us. We are at time for this session, so thank you for that as well. But what that means is that if there are follow-up questions, we do have Will's contact information. It sounds like members of the plenary can reach out to him directly with that feedback, or if they would like any other engagement from the SANDBOX.